Welcome to Investment Immigration Conversations. As ever, I'm Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Well, today I am with a luminary and soon to be luminary in the EB-5 space, my good friend Suzanne Lazicki, and our new attorney, Counsel Joel Hankin. Welcome.
Great to be here.
Happy New Year. Happy New Year. It's still January, so I feel I'm within my rights to wish folks Happy New Year. Suzanne, as I was saying before we opened, you need no introduction. Truly, you have become this unexpected celebrity in the EB-5 space, and because you're a trusted voice, because you fearlessly publish data and express opinions that not everybody may agree with, but are based on your observations and on the data. And for that, you have received recognition, and you are a greatly respected figure in this space and much needed. So thank you.
Thank you.
Joel, welcome. And we're very, very proud and pleased to welcome Joel to the fold at CLP. And I'm just going to read to you a little bit about who he is. That's published right on our website, so take a look. Joel Hankin is an experienced litigator, somebody we need in these times, and former special counsel at Kelly Dry Warren in New York. He practiced more than 2 decades there with a focus on complex commercial litigation, internal investigations, and alternative dispute resolution. His work has spanned high-stakes matters in state and federal courts, in multi-jurisdictional, multi-district proceedings, and regulatory investigations involving the SEC and DOJ. We certainly see some of those in the EB-5 space. At Kelly Dry, Joel managed cases from inception to trial, overseeing motion practice, discovery, and witness preparation in disputes involving securities, financial services, employment, and technology sectors. He has represented clients ranging from major financial institutions and fintech companies to entertainment agencies and bankruptcy trustees, securing successful outcomes in multi-million and multi-billion-dollar actions. So you can see why I'm delighted to have Joel join us. Thank you, Joel.
Thank you. Great to be here.
Yay. All right, well, we have got our work cut out for us because this is our kickoff to the new year webcast. And we have promised folks, we're going to talk about trends, we're going to talk about insights, we're going to talk about strategies, we're going to talk numbers, we're going to talk about subparagraph M, we're going to talk about the gold card, touch on it, and of course, the EB-5 for a Good campaign that we launched late last year. So we've got to start with numbers. Oh my gosh. Suzanne, you are the industry's numbers guru. You've heard it here, folks, and you know it. What's going on? Tell us. I mean, what are you seeing? What do you think are the big numbers to focus on for us? What do we know? What don't we know? What do we have to know coming into 2026, this big important year?
Well, the numbers I am interested in are, number one, how many people are starting the EB-5 process, because that's what creates backlogs. Number two, I want to know how people are moving through the process, who's getting I-526E approvals, because that determines when there's going to be a date in the visa bulletin. I also want to know, are visas getting issued? because that's also very important to how is this queue moving and what can we expect to see in the visa bulletin and for future wait times. As far as the first issue of the people who are starting the EB-5 process, we know right now we just have data through June, and as of that point,
June 2025.
June 2025, there were over 6,000 investors, each in rural and high unemployment, which means over 12,000 visa applicants, each in those categories. And as far as the rate that they were coming in, the first half of 2025, there were enough rural investors and high unemployment investors to take a whole year of visas. And so, well, yeah, actually 2 years of visas in a regular year, 1 year of visas in a normal year. So if every 6 months you're bringing in 2 years worth of investors as far as how many visas you have to get, this is just a much bigger crowd than the rural and high unemployment categories can take, which leads to a question that I'm interested in talking to you later about as far as the unreserved category. Right. And then as far as how these queues are moving, the processing volumes have been really low through the last report as of June, so low that it's kind of not surprising that we're still not seeing dates in the visa bulletin, just because I'm not sure they physically have enough applicants. Even if they do physically have enough applicants, I don't know if they're issuing any visas because the Department of State stopped publishing their reports disclosing what they're doing. So this is another thing I'm very curious to hear your insight on is, are you seeing any movement as far as people getting visa interviews or adjustment of status happening?
Very few. And fewer in the last few months than in 2024. Mm-hmm. So our office mirrors what you're reporting from the numbers and anecdotally. There does seem to be a sluggishness in the flow, which, I mean, how do you feel about that, Suzanne, observing the numbers? Because on the one hand, the sluggishness means we have the gift of concurrent adjustment longer. But on the other hand, it means there's inefficiency and eventually loss of these numbers, unless we're successful in the litigation that would allow the numbers ending up in the unreserved from the reserve flow over to stay there without flowing up to EB-1. If we win that litigation, then we're in a much better spot because those numbers will never get lost from the EB-5 ecosystem. But what are your feelings about this sluggishness? I mean, I have two hearts about this.
Well, yeah, I think that we probably both do because we have hearts for the investors and for the regional centers. As far as the sluggishness, the positive side, as you say, it keeps the window to file adjustment of status open longer. It also creates a longer window for visas just to get issued first in, first out without regard to country limits. And so more Chinese and Indian investors can get in under the gate before the visa bulletin starts to put the stoplight on them. That's a good thing. But as far as long-term, how long is it going to take all of these hopeful investors who have committed their money and started the process to actually get visas? It's going to make that longer. Number one, because just fewer visas are getting issued, visa issuance is getting put into the future. Some visas are getting wasted. And then many more people are applying right now than would if people could see transparently in the visa bulletin, we've got a problem. I think there are a lot of investors who are starting the process thinking, not knowing about those 6,000 plus investors who came in before them, just knowing there's a C in the visa bulletin, I think I'm going to be okay.
I mean, does that surprise you? I mean, okay, in 2013, 14, 15, okay, so there was a lot less visibility, a lot less information, far fewer communities. But now, this is all we talk about. All we talk about is the invisible backlog and when, and it's a question of when and not whether. Does that surprise you that, I mean, could that really be the case that investors are going in and coming into the program with some illusion or delusion about the invisible backlog?
Well, it is true that the people I talk to are fairly well informed, but I assume that the people who come to talk to me are the ones who spent a lot of time doing research, and they researched so much they finally found my little name and came to talk to me.
But those are the folks. That's the first half hour of our consultation is a deep dive into the numbers. So, I mean, those are the folks who are ready to make this substantial investment of their life and time and resources. So, yeah, what do you think?
Yeah, I guess maybe the visa bulletin alone is not too misleading, I guess, but the calculation and predictions are really confusing, and one reason for
Despite
that,
your best efforts.
well, yeah, because there are two questions for how long is it going to take a visa. One is how many people in line. That's hard enough because we have old data and we have to guess for everyone who starts who's going to actually finish.
And the multiplier.
Yes, but then the really confusing thing is how many visas are going to go out to and be assigned every year and to whom. And this is one of the areas where I was hoping to get some free legal advice on the call from me and everyone else here.
Disclaimer. Check with your own counsel.
If you're a high unemployment investor and you make that high unemployment investment, you get your approval letter. It says on your approval letter, you're approved in the high employment category, you're approved in the unreserved category. I mean, I'm looking at that approval letter and thinking, oh, this is good news for timing because high unemployment only has 10% of visas. Unreserved has 68% of visas. That's a much bigger pool to choose from. So you and the 6,000 plus other high unemployment investors are, you have some hope if unreserved is on the table for you. If unreserved practically is not really on the table or could go off the table or be practically inaccessible, you've got a big problem. So this is what I kind of want to pick your brain about is
I think this is huge.
option to select a visa.
I would love to spend the rest of our time with you on numbers, just talking about the unreserved play. Because, I mean, it's so exciting that we're so far along with the India backlog and unreserved. And it's like we're almost there clearing the pre-RIA backlog and unreserved for India right now. So that means that that unreserved would open up. And so what is the effect of that? For sure, we know from the numbers that you just recited, we know that there's a backlog in the set-aside categories. So once the unreserved starts to open up, and by your estimates, it's around, very manageable, let's just say maybe 5 years, 6, 7, something in that neighborhood. The 68% opens up then, we've got this backlog in unreserved. What happens? And I think our working assumption has been that the reserved backlog would march into that depleting bucket of unreserved, right?
Well, this is what I'm asking you. Can we count on that theoretically?
Yes, I think we can. I absolutely think we can by statute. The statute contemplates that first of all, the roll across mechanism. We're gonna max out on the set asides in rural and high unemployment. Then, if there's any left over, those numbers would roll into that same category for the next fiscal year for one additional year. And if they're not used in that category, then they will then flow into the unreserved bucket. So I think, the statute already contemplates this intra-bucket migration. And as we were talking about before going on the call, the pre-RIA mechanism also operated in the same way, but in reverse. So we had set-asides under the old law. We had set-asides for regional center applicants and for TEA applicants. And we had a situation like we will very soon have, where the demand for those set-asides exceeded the set-aside limit. And so the State Department drew freely from the remaining 7,000 to fill that demand. And it was fluid, it was seamless. So I think that there is enough precedent, framework, logic in the existing RIA mechanism and the precedent with how the visa office counted and allocated visa numbers pre-RIA for us to safely assume that that would certainly, and not to mention the approval notices themselves. And the NVC notice that that 526E approved visa applicants get to elect the bucket that they wish to go into post 526E approval. So I think all of that points to the answer being yes to your question, that yes, we should be able to rely on that investor being able to elect whether he or she goes into the unreserved bucket or the HUA. The mechanics, I think, are to be sorted out.
Okay, so you're seeing friction in the process now to actually take advantage of that?
Yeah, well, friction, yes. I mean, a little bit on the State Department side with the NVC process, because I think as I reported in earlier context and to you right before we hopped on, there is the notice that NVC issues to visa applicants when it receives the 526E file. And applicants are asked to choose the bucket they want to go into. And so the mechanical issue there was, at least in the very beginning, you would try to choose unreserved and it wouldn't stick. You know, so for our early investors, we would try to get them in the like being good citizens, you know,
right.
And so we couldn't. And so eventually we had to tick rural or whichever set aside category they were going into so that they can progress in that process. So, you know, it seems to contemplate that we should be able to make that affirmative election at that stage. On the USCIS side, there is no mechanism for us to make that affirmative election yet. So I think that we need that at some point soon.
Do you know if people are trying? Because when I look at the I-485 inventory report, it does list a number of recent priority dates in the unreserved category. And I'm guessing that they're not 1,050,000 investors. So do you know how people are doing that?
How people are doing what?
How they are telling USCIS, put us in the unreserved category?
Well, so the form is very important. The choice is made on the 526E form. And so the petitioner, the investor, can tick however many categories as apply to that petition. So you can actually choose, and there are projects in the market now that qualify for both high unemployment and rural. And so you can tick, and then the service has to take that into account in its processing. And so it remains to be seen. But I believe that, you know, when you take HUA and rural, that the service is compelled to give that case prioritized processing treatment, to treat that case as rural for processing time purposes. And so that case is going to be treated as rural, get prioritized processing. But then the question is, we know that the unreserved will drain. The the backlog in the unreserved will eventually clear in some years. And when that happens, what will be the mechanism for those investors to choose? And will they be allowed to choose at that stage, at a later point in time? I mean, let's suppose in the NBC context, where we do have that mechanism to make an affirmative choice, assuming that the kinks are worked out and we can do it. Will investors at a later point in time be permitted, okay, I chose rural time one, but now rural is backlogged and unreserved is open. Could I now switch? Again, I think we should be able to, because this is sort of, it's kind of baked into the system. We can go, applicants can go from one preference category to the other by alerting the agencies. So for example, if you're the spouse of a green card holder, but your husband or wife becomes a citizen, a naturalized citizen, then you are in the immediate relative category. You've migrated up the preference categories. And you get the benefit of that with notification. So I think the overwhelming weight of precedent and statutory framework and everything else points to us being able to do that. Whether like absolutely positively yes, and the mechanics are to be determined.
And then let me
Go ahead.
If you were to do that, I mean, are you giving up your spot in the TEA preference at that point? I mean, if you're moving from a TEA to an unreserved, right?
That's a great question. And the answer's got to be yes.
Has to be yes.
You cannot hold two spots.
Yeah, but this is a very important point for people to think, can I count on access to an unreserved visa? Because it is the difference in years of wait time expectations, depending on whether or not they will be able to count on access to an unreserved visa.
100%. It's going to be all about unreserved in the coming years. Whew, I'm so glad you're there. All right. Keep the engine running. Let's pivot a bit to litigation and subparagraph M. We started getting the demand for counseling in the subparagraph M space.
Meaning the good faith investor protection.
The good faith investor protection, yes. The best part of the RIA. And I realized immediately that we would need to get into the courts to fully take advantage of subparagraph M in many different ways, not only in initiating suit against the agencies, but there are suits already. If there is an SEC initiated action, if there are civil actions involving the regional center or the new commercial enterprise and the investors are on the sideline, there is a need to appear in these actions, even if you are not a litigant directly. So there is a need for this expertise, very specialized, high-level expertise in litigation, in particular in representing subparagraph M investors, in good faith investors. And again, welcome, Joel. So let's talk about that. And you know what? I'm going to invite you. I said to keep your engines running. I'm going to invite you to come right back in this discussion in terms of, what are your observations? What are the questions you're getting from investors and other participants in our space about subparagraph M? And Joel and I are going to try to answer your questions and throw in our remarks and observations.
Okay. Well, yes. If I can just ask you a question right now that I got this morning. And
disclaimer: this is not legal advice.
Yeah. So this person says, I'm worried that my regional center has not created enough jobs. My regional center has been terminated. USCIS has given me 3 options, and the third option states I can invest $800K in another regional center and retain my priority date. do you know any regional center who's dealt with good faith protection investors and takes 500K and have created or in the process of creating jobs?
There's a lot there. All right, Joe, I'm going to kind of get things warmed up and started and just like come in whenever.
Yep.
So I'm going to guess that the due date for this is end of March. The service issued a spate of these, many 180-day notices that it is required to issue under subparagraph M when it terminates a regional center or debars a new commercial enterprise. And this notice gives three options. So I'm going to kind of unpack and walk back this whole scenario, and then we'll get to the question. The investors are required to receive this notice from USCIS that says, hey, your regional center has been terminated or your new commercial enterprise has been debarred. And we're going to give you three options, and these options are key to the statute. Option number one is, I'm fine, thanks. I continue to meet the eligibility requirements. Option two says, thanks, I need to amend my petition. My new commercial enterprise is going to, since the regional center has been terminated, my new commercial enterprise is going to affiliate with another regional center that's in good standing. Option number three is going to say, neither of the two above, I'm going to make another qualifying investment in another new commercial enterprise. Those are the three options that are available if there's been a regional center termination. There will be a different menu presented to investors in the event of an NCE debarment. We have not seen an NCE debarment notice. As far as we know, we are not aware of any NCE debarment to date. If any of you wonderful folks out there are aware of an NCE debarment, please let us know. We're very curious. Contact at Carolyn Lee PLLC or Suzanne. We just want to know. Different menu options. So when are these options kind of, more viable than the others? Option one is we're eligible, no thanks, we're fine. This would probably be, again, not legal advice. So I'm trying to, skirt these very difficult to navigate lines sometimes. That might be the appropriate option, where let's say a fabulous regional center that's done wonderful things for its community voluntarily unwinds, voluntarily withdraws from the regional center program, as it is permitted to do. There's written guidance on this. And before it has done that, it's completed all the projects, created all the jobs. And it's also possible that even after the regional center is terminated, these NCEs live on, right? These as entities, as corporate entities with independent obligations and life, they continue to live. And so even if there's been incompleted job creation at the time of regional center termination, a fabulous new commercial enterprise can continue to do its job of shepherding the investors, being responsible, being the fiduciaries, and doing its job of creating jobs. All right. So in those instances, option one comes into play. Option two, my new commercial enterprise is going to affiliate with another regional center in good standing. When might this come into play? Well, let's imagine a regional center that has a business where the business model is sponsoring multiple unaffiliated projects and new commercial enterprises. And let's say it's terminated for whatever reasons, but it's got these clutches of fantastic new commercial enterprises that are doing their job, that are doing the work of building the thing, doing the thing, creating jobs, taking care of the investors. But what are they going to do? Now they don't have this regional center affiliation support. Well, they get to keep doing what they're doing and complete what they're doing, if not yet complete, by reaffiliating itself with a regional center in good standing. And generously, the law, subparagraph M, allows this regional center to be anywhere. It doesn't have to cover the original geography. It could be anywhere. It's got to be in good standing. And then you click into it and you go about your merry way. You keep doing that work. Okay. Option
And
3.
we've seen that happening.
Pardon?
And we've seen that happening.
And we've seen
have
that
been,
happening.
right.
Exactly. Exactly. We would advise in those scenarios. Option 3 is those two options really aren't, we don't have completed job creation. I know I'm not there, or I'm really not sure I'm there. I'm not getting any information, or the NCE MIA, don't know what's happening there. Possibility of reaffiliating with a good regional center, I don't know. Maybe not. Doesn't seem likely. Then option 3, thankfully, is there because the investor is in control of that option. And the investor can make a new qualifying investment into another new commercial enterprise. And so one of the big questions here is how much? Pre-RA investors originally invested 500K, post-RA investors have 800K. So what is my new qualifying investment? Is it 800K regardless, because that's the world we're in now? Thankfully and generously, and in keeping with the spirit of subparagraph M, thank you, IPO, we have clarity on this question. Pre-RIA investors, your qualifying investment is at the 500,000 level. Post-RIA, it's at the 800,000 level. Okay, and it's got to be qualifying. It doesn't spell everything out. It doesn't have the entire 203(b)(5) in there, but it's got to be qualifying. It's got to create the jobs. It's got to be a sufficient vehicle for you to sustain your investment over the required time. Okay, and meet all of the other requirements of bona fides, of regional center compliance, et cetera, et cetera, et cetera. Now, questions?
My question is, how is option 3 practically possible to exercise?
Mm-hmm.
Because they say that you can do 500,000, or that there's also like or the amount necessary to satisfy job creation. And no. Okay, well, leave that aside. Okay, let's just say you make a qualifying investment of 500,000. The form I-527 that they suggested for this has you justify that 500,000 by showing that it meets the TEA definitions under the legacy TEA rules. So is there any regional center out there who will take a $500,000 investor and get the TEA designated by the state under the old rules? And is it necessary for the investor to go into an I-956F approved project? Is that what it means to be a new commercial enterprise in good standing now? Do you see this happening in practice, and how is it working?
I truly do, and it's important. We may not have all the details worked out, and surely there are those. But it is critical that that avenue remain open and viable, because there are investors who have no other choice. They have no other option to enable them to continue their EB-5 immigration. So however way we get there, we've got to make this option work as intended by statute. And the great news is that so far, the agency, the community, every indication is that we're all aligned in trying to really give full effect to the intent behind this subparagraph M. So we're going to get there, but we have not worked out all of the kinks and the procedural necessities.
So for somebody who has 180 days to exercise option 3,
Yeah.
what should they do?
Yeah. Well, so notice that they do, thankful. I mean, I don't know whether by design or not, but they're due March 27th. Or whatever the date is. And so I am rather holding out the hope that sometime shortly before that, we will actually have a form. And that this will clear up some of the questions, and that investors making that election will be able to file on that form and have greater clarity. And this will indeed be important because the options contemplate an email response. And we do know that there is an email inbox size limit. And so when we think about, sourcing 800,000 and 500,000, those procedural guidelines are going to be very, very important. So, yeah, and I have other thoughts, but I think those are procedural niceties. They're important, absolutely, but we're going to get there.
And let me just add, I mean, this is arguably the system working in its best case scenario to some extent, right? USCIS has recognized an issue. They've terminated a regional center. They've issued the 180-day notice, right? This is while as Carolyn, I think is saying, right? Procedurally, there are still going to be hoops to jump through and forms that need to be issued and things like that. At least in this instance, the system is working, and we're not in a litigation setting. We're not approaching courts. So that is, at least right now, a good situation given the context.
Yes.
Let me ask you, if a regional center came to you and said, we would love to help accommodate investors who are seeking this good faith investor safe harbor. I have an I-956F that's approved for $800,000 investors in a high unemployment area. And the regional center asks you, can I accept a $500,000 investor with the old TA definition? Is this going to be going against my I-956F approval and everything I said in my offering documents that I was going to do to make this exception for this guy?
We are grappling with some of these questions and advising clients through this daily, our project and regional center clients. The big picture answer is yes, there are for sure a number of regional centers and projects that are opening themselves up to receive the good faith investors. And they are amending their original project documents to enable taking these investors in. And it is very, very possible. And it is being done. It has been done. Yes, to answer your investor's questions, yes, there are projects that are not only willing, but designing themselves to be able to fold these investors in.
Okay. So I guess just somebody who's on their 180-day clock here, they can call you and maybe you can give them some more details.
They absolutely shouldn't, I don't mean to suggest, oh, don't worry about it. No. This is very important. Get on it. Get all the information possible that's out there. This is like our third webcast on this issue. Yeah, start making decisions and getting things in play.
One thing that isn't very clear to me looking at the language around the option 3 is to what extent it's all new. It has to be a complete 500,000. It has to be a full 10 new jobs. Whatever happened with your previous deployment doesn't count. Do you count aggregate before and after? It's that there's the language that you can make a qualifying investment or otherwise associate with another NCE. Does anyone have an idea what that or otherwise associate with refers to? If there's something you can do other than just make a completely new 500 investment?
I'll address the nature of the investment. So the RIA, so paragraph M by design, is very open and flexible in terms of the funds that an investor can contribute to the next investment. And we talked about this, in the course of drafting and designing this language. So investment, insurance proceeds, recovered funds, other capital, they can all count toward the qualifying investment for job creation. And this specifically addressed the pre-RIA RFEs on 829s, where the agency refused to take other capital and recognize it for job creation. And so this statutory language specifically addresses that and says we're open. It's got to be lawfully sourced, full stop. There's no, that is where we start. But it does not have to be your specifically redeployed capital, recovered capital. Other capital can also qualify.
And it would, and you would retain priority dates. You would retain the time frame from your original investment critically. Right. So even if you're adding new money, whether it's insurance recovered money from the first NCE, JCE, your time frame isn't reset even if you're putting new money in.
Critically important. All about the basket of remedies that paragraph M confers. And age out protection. Age out protection. The many pre-RIA, disillusioned pre-RIA investors with aged out children who are now investing in the post-RIA. I don't know how you put this. If you've had the misfortune to suffer regional center termination, NCE debarment, then this is the silver lining.
The draft form I-527 that they put in the fee rule for people who are exercising this option, I noticed that they ask about job creation both by the first project and by the deployment. And I'm wondering, is in the background of that the idea that you get to count aggregate? If your first deployment created 9 jobs and you just needed 1 more job?
100%, Madam. That's what we would be arguing. I mean, the issue could be moot. If your second thing is like gushing jobs and, it's like 25 jobs per, maybe you don't worry about it. But if it's tighter and those jobs from the first deployment ought to count, yes. And that's existing policy, right? You get credit for the job creation. The issues that we're seeing are what the job creation, whether or not that claim, that number holds, that is a very serious question. And often what is presented as a number ought not to be relied upon. So we're not talking about that at the moment.
In the first JCE scenario, in your first investment where there has been a problem.
Exactly.
I see. Okay, and then my last question on that is there, to me it looks like there's maybe some ambiguity in the language that there's an alternative to investing the 500,000. There's the or otherwise associate, and then there's the mention one point of invest additional capital necessary to satisfy any remaining job creation requirements. Is that wiggle room to do something other than invest a full 500,000 in a new one, or do you think not?
For regional center terminations, I think not. For NCE debarments, I think yes.
Okay, interesting.
there's a distinction in the statute, basically, that each of these are in two separate sections and they have two separate remedies. So
Hmm.
the topping up remedy is in the case of the NCE department
Right.
section only.
Hmm.
And as Carolyn mentioned, that hasn't been tested and hasn't been opined on
Yeah.
since it hasn't happened.
Yeah. So I also wonder about all those investors in troubled projects who don't technically qualify for the subsection M protections because the regional center hasn't been terminated. It's just a problematic project. I don't know if Joel has any comments on how he can step in maybe along the side of protecting those investors that don't get this option, but maybe you have other ways to help fight for them in troubled project scenarios.
Yeah, I mean, certainly this is the much more difficult scenario than when everything is working and the 180-day notice is issued. And I think we're also seeing in some instances judges and courts that need to be educated on these issues and the RIA. I mean, this is new law for them also that they haven't had the chance or need to weigh in on. There may be ways to try and reach out to USCIS. There may be ways to try and force USCIS to act. The problem is, of course, there's a lot of discretion involved on their end as to, whether or not a debarment is required, whether or not a termination is required. It's one thing if certain fees haven't been paid and they can point to something. There's a lot more ambiguity if there's some malfeasance that's been alleged or is suspected. There's a lot of ambiguity in that situation as to whether or not USCIS wants to act, is required to act, or will act. And there are, I think, mechanisms that we have to try and push that along, but those, for the most part, have not been tested yet.
Mm.
All right. Ooh. Ooh. All right. Let us talk a little bit about the gold card, just to touch upon it. But I really want to spend a little bit of time is just sort of like mapping out the rest of the year, and see what happens in our discussions and in our remaining just a little bit of time. So the gold card, it is here. It is live. The portal is open. Applications have been filed. As far as I know, no gold card has issued. And I think that we could do a whole lot of good in advancing the gold card as a robust and very real option. If we were to find a way to codify the benefit into statute, because what we are hearing from the market, from truly genuinely interested investors, is the concern about the future administrations and their ability to, by executive action, undo this benefit. So I think that to really get traction and legs on that, we can take some steps to make it more robust and clear up some technical questions as well. Suzanne or Joel, anything further on that before we go on?
A silent blush is my comment on the gold card.
Just like read about it. I've got a lot to say. All right, please read about it. Before closing with EB-5 for good, let's just take a moment to appreciate, or to just kind of picture what 2026 has in store for us looking ahead. So we've got the visa backlogs that we've just been on pins and needles about every month for the past, I don't know, year or so. And as we've been reporting, maybe because of the sluggishness, that cutoff date gets deferred and deferred and deferred, but eventually we will see a date. So we've got that coming. We've got the September 30, 2026 grandfathering sunset happening. And then at some point this year, we are going to be turning to the CPI adjustment to come to the investment thresholds starting January 1, 2027, promising to ramp up the minimum threshold to the 900,000 neighborhood. And then looking to that year, September 30, 2027, looking that far ahead is going to be inevitable this year. So when we kind of map out those huge events ahead of us, Suzanne, what are your thoughts?
I have a question for you again, as lawyers. So, thinking about with the reauthorization, thinking about how that happened in the past, 2022 was unusual in actually having a big law associated with reauthorization. All of the other ones, it was just like a sentence, add on another couple of years, add on another few years. It was only until the extension, or when it came up in 2015, and Grassley was upset about the EB-5 program, and he said we have to reform it, or we can't just give it a good extension without reform. And so there was that whole long discussion from 2015 up until it finally culminated in 2021 to get a reform bill to go with the extension. How do you think it's going to look this time? Do you think we're looking at like a big bill to have to go, or do you think it's possible that it would just be another one sentence, 3-year extension, 4-year extension? Do you think that we're going to go into an endless series of it being advanced a few months at a time by continuing resolution, which is what happened between 2015 and 2021? What do you visualize happening?
Yes, well, let us all hope that it isn't the last with serial tiny CRs. I think it's more going to look like your second scenario, where we'll have more or less a clean extension for X number of years. That's what it's sounding like at the moment, by way of reporting what seems to be afoot at the moment. So, and for me, when I think about that, the first thing that comes to my mind is, well, okay, so does that mean we're going to have a preservation of this asynchronous, grandfathering and the program sunset? And evidently, or rather, apparently, that is going to be fixed. And so if we have a clean reauthorization and extension, that anomaly is going to be corrected. So that's great. So, and, at least in IIUSA and in the Public Policy Committee, we are working we're working as if we could have a redrafting or, a substantive revision to this iteration. But it's sounding more like it's going to be a reauthorization, a continuation, which would be great. That's fantastic. We should just keep our sights on what we really want, which, are corrections, improvements, permanence.
So, but do you think there's likelihood to be corrections and improvements in context of legislation? It sounds like not, right? You're thinking the legislation probably would just be to extend it.
To extend it, right.
Yeah.
Yeah. But we've got to stay very open to opportunities to get those corrections and improvements and permanence in. And that we're seeing that. We're seeing that mindset in the advocacy community. We're not going to miss out on opportunities to go for it and to get what we really need in EB-5, which is stability.
Mhm.
How'd I do?
Another thing I'm curious about. Oh, I see. We're almost out of time. For
Okay.
you, with the upcoming grandfathering deadline and the regional center expiration, is this something that you kind of sit your new clients down and warn them about risk factors associated with this? Or do you feel like the grandfathering gives enough of a protection that they don't really need to worry about what if scenarios?
Oh gosh, I don't think I've ever uttered the words, but you don't need to worry about dot, dot, dot. I mean, at the end of our consultations, it's a wonder anybody, agrees to go forward with this. So no, I mean, grandfathering is, so what we have to focus on is the spirit of the thing. The spirit of the grandfathering section is to address this. Yeah, it's difficult to put in words. You have put everything on the line for a dream. I do think, even if one has blinders on about lots of things, wait times or whatever, it is a very real thing to cut a check, make that wire, and to say, I'm going to sign on to this, me and my family, my future, because the uncertainties are undeniable. And so you've done this, and then the program sunsets, and there's no reauthorization. And what is going to happen? What is going to happen to you? You've made an at-risk investment where you have signed, I have no right to demand my money back. And the program ends. That's a horrible situation. So the intent of the grandfathering section was to address that, was to fix that. And so we've got to give effect to that intent. And that's what I place a lot of faith in. And so, but then, everything turns on the intention of the effector, those empowered to give effect to that language and intention. So I do hope, and I do continue to have faith that that language, when it comes time to put it in play, will be given its due effect as intended, as Congress intended. But I worry about everything, Suzanne.
Mm-hmm.
I don't know if you know this.
Yeah, a lot of things to keep an eye on, and the regulations coming out this year. Probably, I don't know if you expect any significant earth
Well,
moving from that.
well, I think they're trying. I really do. I mean, I think it would be really, really great. I mean, then there's been regulatory activity, right? There's been NPRM fees and so forth. But we do have the program itself sunsetting in 2027. And hopefully, I mean, it does look like the stars and the moon are lining up so that we will have a reauth, without too much drama. I hope, an elision from the September 30th, 2027 date to the next without any gap, without drama would be fantastic. And I mean, it seems like that could very, very well happen, which again would be amazing. Um, I mean, we can have regs, substantive regs before the program, before September 30th, 2027. That would be great. That would be great. That should be the goal, is let us have substantive regulations before this year, 2026.
Well, here's hoping.
Fingers crossed.
Fingers crossed. Okay, well, there was so much, we covered so much, and there's always more to say, especially with you, Suzanne. And Joel, I'll be calling you up immediately. Well, thank you, everyone. Wow, oh my gosh, there are like lots and lots of questions. All right, in the spirit, we've got to answer a couple. Panelists, can you see these questions? Let's each pick one. Oh yes, EB-5 good. let me close with that. Each of us, let's pick a question.
It seems like a lot of these are about the good faith investor. Carolyn, I forget if you had a webinar specifically on this topic, right? Would that address a number of these questions?
Yes, yes. Scroll through our library. I believe it was it October? It was in the recent past quarter, I think we devoted, where we had a lot of discussion on them.
Yeah, most of these are a subsection, and there are a few about timing. And this is something that I go into a lot of detail on my website. You can find information. I also do consultations. The short story is that for both rural and high unemployment, there are so many people in line from China and India that there's not a way to avoid retrogression, wait times, and backlogs in those categories, unless you happen to be really lucky and get non-first in, first out. But even I would say the chance to be lucky is getting narrower now, just because there are so many people who are in the process. And you can reach out if you want to discuss that in more detail. As far as someone who's not from China and India and not subject to the country cap, people don't need to worry about wait times so long as there is unfettered access to the unreserved category as well. If there isn't, then rest of the world investors also are going to have cutoff dates and high unemployment. So that's why the topic Carolyn and I were discussing is so important. It's generally speaking, the rural category is less crowded now because it has twice as many visas as high unemployment, and it has up till the last reported date about the same number of applicants as in high unemployment. But it does get more complicated when you figure in, if you can assume that there's access on each side to unreserved visas as well as to the reserved visa.
Yeah. And the trend is toward higher and accelerated usage in rural.
Yes.
Yeah.
But yeah, if you want to talk in a lot of detail about the timing questions, you can reach out to me. And it sounds like if you want to talk in a lot of detail about subsection M, Carolyn and Joel can be assisting.
Yes, and do look through our library of materials. We have quite a lot there, and also on our website. And they're all free. EB-5 for good. EB-5 for good is a double entendre. It's EB-5 for good, as in EB-5 for good, for the good of the communities, and EB-5 forever, EB-5 for good. And this is a campaign that our firm launched in November of last year. And we have opened up a contest for projects to submit a proposal to us through contact at, that describes your project for the good of the community. And we will choose one of those projects, and if any meet our criteria, and which are posted, which we discussed on the prior webinar, and we will do that 956F application pro bono. That's our nod to doing EB-5 for good. We are going to close the application process at the end of February, and hopefully a wonderful candidate will emerge, and so you'll hopefully hear more about that in later events to come.
Great.
Great. So everyone, thank you so much. Have a wonderful rest of your day, and Happy New Year. Happy wonderful 2026. And we'll see you next time. Thank you, Suzanne. Thank you, Joel.
Thanks. Thank you.
Bye.